Two marks walk into the trademarks registry. The first is a descriptive word used heavily in the market for 20 years. The second is a bottle shape that every consumer recognizes instantly, but that shape is necessary for the bottle to function as a spray. The first mark gets registered, the second is refused, and no amount of use or recognition can ever save it. This outcome comes down to the precise distinction between Section 9, subsection 1, and Section 9, subsection 3. Understanding why the first defect is curable, while the second is an absolute bar, is the most tested distinction in the exam. Today, we will map the exact chronological filter applied by the registry. We will walk through Section 9 through Section 16 to understand exactly why marks fail, and more importantly, how to identify which failures are permanent. Every refusal at the Trademarks Registry falls into one of two categories: absolute or relative. Absolute grounds, found in Section 9, attack the mark itself. The mark is rejected due to its own internal nature. It might be descriptive, deceptive, or scandalous. The registry raises these to protect the public interest, preventing a private monopoly over common words or functional shapes. Relative grounds, under Section 11, attack the mark because it conflicts with someone else's earlier mark or right. These exist to protect private owners. The first level of the registry's filter is Section 9, subsection 1, the distinctiveness bars. Section 9.1 has 3 clauses: devoid of distinctiveness, exclusively descriptive of kind or origin, and customary in trade. But the proviso offers a lifeline. A mark won't be refused if it acquired secondary meaning from use strictly before the application date. This chart shows exactly how this works in practice. This is how highly descriptive marks like Dettol, Bisleri, and Fair & Lovely overcame their initial Section 9.1 defects to reach the register. Section 9.1 bars are the most common objections an agent will face. As long as the applicant provides sufficient evidence of prior use, these defects are entirely curable. The leniency of the proviso ends at Section 9, subsection 2. This is the realm of deception, morality, and national order. Here we find 4 specific triggers: marks that deceive the public about the goods themselves, marks that hurt religious susceptibilities, obscene or scandalous matter, and prohibited emblems. Clause D is particularly rigid, dealing directly with marks prohibited under the Emblems and Names Act of 1950. This covers the national flag, the Ashoka chakra, and the Olympic rings. These create an absolute bar. No acquired distinctiveness or consent can cure it. This strictness continues into Section 9, subsection 3, the shape mark bars. A mark shall not be registered if it consists exclusively of a shape resulting from the nature of the goods themselves, a shape necessary to obtain a technical result, or a shape giving substantial value to the goods. Section 9.3 has no proviso. A functional shape is incurable in trademark law because it belongs strictly in patent law. No amount of consumer recognition will save it. Once a mark passes the internal filters of Section 9, it faces Section 11. The mark itself is legally sound, that it now has to survive comparisons with existing competitors already on the register. Section 10 presents an immediate dead end. If you apply for an identical mark for identical goods already registered, it is an automatic refusal. Section 11.1 covers nuanced scenarios: identical marks on similar goods, or similar marks on identical or similar goods. The standard is likelihood of confusion. Marks are compared as a whole, using the anti-dissection rule, through the eyes of an average consumer with imperfect recollection. The classic authority for evaluating phonetic similarity is the 1906 Pianotist Test from the UK, which is universally applied by the Indian Registry. In India, the Supreme Court localized this test in the Amritdhara case, establishing that Amritdhara and Lakshmandhara are confusingly similar by both look and sound. Section 11, subsection 2, introduces a completely different standard: cross-class protection for well-known marks. If a mark holds sufficient reputation in India, it can block applications for completely unrelated product classes. Registering a famous sports car brand for a restaurant is refused for taking unfair advantage of the earlier well-known mark. There is, however, an important escape hatch. Under Sections 11.4 and 11.5, the registrar may allow the registration if the proprietor of the earlier trademark provides explicit consent. Relative grounds exist to protect private monopolies. Because the public interest is not at risk, a private owner's consent can cure a relative defect. To utilize Section 11.2 cross-class protection, the mark must officially be declared well-known. Subsections 6 to 9 provide machinery. The registrar evaluates 5 factors: knowledge, use, promotion, registrations, and enforcement. Exam questions test what is not required. Section 11.9 states the mark need not have been used in India, nor known to the public at large. Since the 2017 rules, proprietors no longer have to wait for a court dispute to establish this status. They can apply directly for well-known determination on Form TMM, accompanied by a fee of 1 lakh rupees. Section 12 provides the ultimate historical exception to Section 11 conflicts, where 2 proprietors have independently used identical marks for the same goods, in good faith and without knowledge of each other. The registrar may permit the registration of both marks as honest concurrent users. To resolve the conflict on the register, the registrar will typically apply territorial conditions, granting one proprietor rights in the north and the other in the south. Section 12 acts as a pressure valve, allowing the strict rules of Section 11 to bend around the reality of independent commercial expansion. The final stage of Chapter 3 contains highly specific, specialized blockades found in Sections 13 through 16. Section 13 applies to the pharmaceutical and chemical industries. It creates an absolute bar against registering the commonly used name of a chemical element, or a World Health Organization INN. No drug company can monopolize the generic scientific name of an active ingredient. Section 14 protects identity. If a mark falsely suggests a connection to a real person, the applicant must secure explicit consent from them. For living persons, this means a sports brand cannot register a famous cricketer's name without their written permission. This protection extends after death, but with a precise time limit. If the person died within 20 years prior to the application date, the consent of their legal representatives is strictly required. Finally, Sections 15 and 16 outline administrative rules for mark families. Section 15 allows variations of a mark to be registered as a single series, while Section 16 mandates that identical marks owned by the same proprietor must be registered as associated marks, assigned together as a whole. These final sections close out the registration filter, ensuring that trademark law does not monopolize basic science, misappropriate individual identities, or allow complex brand families to be fragmented in the market. Let's lock in this matrix of absolute and relative grounds with a rapid-fire review. Question 1. Which Section 9 bars can acquired distinctiveness cure? Only Section 9.1. Never 9.3 shape bars, and never 9.2d prohibited emblems. Question 2. This distinctiveness must exist by when? Before the date of application. Question 3. Identical mark, same goods, already on the register? Section 10 refusal, unless the earlier owner consents. Question 4. Well-known mark protection extends to what? Even dissimilar goods and services under Section 11.2. Question 5. Must a well-known mark be registered or used in India? No. Section 11.9 explicitly excludes this. Question 6. How does the registry handle 2 honest users? Section 12. Honest concurrent use, at the registrar's discretion. Question 7. INN pharmaceutical names? Permanently barred by Section 13. Question 8. When is consent needed for a deceased person's name? If the death occurred within 20 years before the application, under Section 14. You now have a complete map of Chapter 3. You know exactly what the examiner is looking for and which defects cannot be fixed. In Lecture T3, we move from the theory of refusal into the actual procedure, examining Form TMA, the fee structures, and navigating the strict 4-month opposition window. Subscribe and see you there.